the recording going. Welcome everybody. Good morning. 12th of October 2022, and we're going to talk through an instruction and circular that came out on assignments and sessions, and then if we've got enough time, we'll talk about scams and the RFQ scams that have been around for 4 years now. What I suggest is let me run through the first couple of slides on assignment, and then we can open up the discussion on that. I've got a couple of discussion points to pose to you. So in August, the newly appointed Chief Procurement Officer issued an instruction 8, and also a circular 120. These were both issued, and they are effectively covering the same content. There are small differences between the two that just refer to PFMA and MFMA in different instances, but the substance is essentially the same. Because MFMA is different, they don't have an effective date, but on the PFMA side, the effective date was the 1st of September for instruction 08. The background to the instruction and the circular is described at the front end, and they're both basically the same. The application of session and assignment in public sector has been a source of a number of application interpretation challenges. Chief among these is the apparent blurring of the line between the concept of session versus assignment, and many using these words interchangeably. And there's court cases where even the courts use the words interchangeably. Furthermore, there has been policy uncertainty as to the permissibility of both session and assignment within, amongst other, the South African Local Government Procurement Regulatory Framework. Section 217 of the Constitution requires that when an organ of state and national, provincial, local sphere of government contracts for goods or services, it must do so in accordance with this system, which is fair, equitable, transparent, competitive, cost effective. And that we'll come back to when we talk about the essence to this. Basically, the instruction and circular is just saying that the application and assignment of sessions and assignment presents challenges in that it may, in certain circumstances, be seen to contradict the constitutional requirements of fairness, transparency, and competitiveness, and that a contract may be executed by a person that was not the appointed bidder, or a competitive bidding process, or a payment made to a person who is not the contracted supplier or service provider. That's the background. Let's look at specifically then the assignment of contracts. Now, it's not very long-winded. In fact, the instruction and circulars are fairly short. The assignment of contracts refers to the transfer of rights and obligations in a contract from an assigner to an assignee. The effect of this is that the service provider appointed through a competitive bidding process transfers the contract in its entirety, that is the obligation, responsibility for rendering the service, and the right of receiving payment for the services to a third party that did not participate in the bidding process, or a bidder that participated in the bidding process but was not successful. So they've got a very specific definition here of assignment. They're saying assignment is where you've got a company that was awarded the deal, and that company transfers the rights in all respects to another service provider, and that service provider then is responsible for delivering the contract, and also receives the payment for the services that they render. So the entire contract, delivery of the contract and its terms and conditions, and the rights to receive payment for that is transferred to a third party. It then goes on to say South African law of contract is based mainly on common law. However, the contracting process for commercial contracts entered into by organs of state is subject to section 217 and other applicable legislation. The effect of the above is that a contract that results from a public procurement process, public procurement processes are required to comply with the requirements of all SCM legislative prescripts, and consequently assignment of contracts is not allowed, as it will be contrary to the principles of section 217 of the Constitution, particularly fairness, transparency, and competitiveness. So they're saying that effectively, someone has entered into a bidding process with the organ of state. that organ of state has made a decision based on all the legislation that exists to award the contract to Company A. And what then happens is Company A decides to assign the entire rights of delivery and the payment of that to an entity which did not participate in the procurement process, or an entity that did participate in the procurement process but was not successful. And basically saying that this assignment of contracts is not allowed, as it is contrary to that principle of section 217. It then goes on to say that clause 19 of the GCC makes provision for assignment of contract, where it says it provides a supplier or service provider shall not assign in whole or in part its obligation to perform under the contract, except with the purchaser's written prior consent. So they're saying the GCC says that a service provider cannot assign in whole or in part its obligation to perform under the contract, but that it can be done with the prior written consent of the organ of state. But they're saying that given what we've just discussed on 217, that is not allowed, and they are busy reviewing the GCC. Here's some discussion points. Before we get to the discussion points, just quickly show exactly where this is. 19.1, it's the only thing under assignment in the GCC. Supplier shall not assign in whole or in part its obligation to perform under the contract, except with the purchaser's prior written consent. So here's some questions. What is the implication, therefore, if a supplier requests an assignment? So a supplier writes to the organ of state and says, I am no longer able to continue with this particular project. Please, I would like to assign the rights to this particular contract to another company, and this is the name of the company, and please would you approve that? What's the implication of that? First one, does it basically mean, which I think it does, that the contract has to be cancelled, and at that point in time, a different tendering process would have to be initiated? Let me go through the other questions, then we can open up the discussion. Are there different stages in the life of a contract that may make the implementation of this challenging? Certainly, if the contract has just started, it's far easier to do it at that point in time. But what if the contract is 50% or 80% complete? So, for example, you've got a 2-year IT contract. You're busy developing a whole, or the supplier is busy developing a whole system on your behalf. They're 50% through the process, and they request then that this project be assigned to someone else. What about the treatment of assignment in other contract forms, such as JBCC? How will this be treated? Because as I understand, and I have not looked into each of those construction contract forms in detail to understand this, but all of them do make allowance for, I understand, do make allowance for assignment. And therefore, until the GCC is amended, must a special condition of contract be included in the tender document to be compliant? Let me give an example of the one that we discussed, and we did tell National Treasury about this when they issued the draft instruction and circular earlier last year. It was in fact about the middle of last year when they put the draft out. A supplier is busy with a contract, but they've been acquired. There's an acquisition that's happened. The supplier used to be ABC with the banking details, but they were acquired. Somebody bought the company, and they are effectively going to fold that particular company up. They're going to close it. The people on the project are going to be the same. The rights and obligations are going to be the same, except they're going to ask now that it's not going to be company A, it's going to be the procurer that would like to complete the project and be paid for it because they've got certainly different bank details. there's a practical example of an instance where that might happen. Sharing that with you because this is one of the examples that came up earlier. Let's open up and see if there are any comments on this. Certainly, we can understand that there is the rationale is right, but at the moment, it doesn't seem like the circular or the instruction actually takes into account these different circumstances. CK, good morning, welcome. You can unmute. CK.
Hi, good morning, Sean. How are you?
Good morning, well, and you, welcome.
Thank you. Sean, I just want to start with your second and third bullets.
Sure.
Before I get to the other bullets. For me, it's neither here nor there where the contract is and what kind of contract form we have used. And I will tell you why. Because for me, the issue is as already well articulated in the instruction, that as an organ of state, as a state-owned entity and as a department of state, you are enjoined to acquire your goods and services in a manner that is aligned with the Section 217 of the Constitution. Now, having said that, okay, whether the contract is just at the beginning or it's 80% complete, you cannot assign it to another entity. But the issue is assignment in itself is not a ground of termination, of canceling the contract. The request to assign, for instance, when they come to you and they say, I would like to assign this contract to company Y, you have to look at the reasons why they are assigning the contract. If the reasons for them assigning the contract are because they can't deliver anymore, then that's a ground for termination.
Absolutely.
But if there are reasons for assignment, like as per your example, is that, for instance, the company has changed its name. For instance, we deal with law firms who change their names on a daily basis.
Often happens.
So they've changed. It was a Mumakwa Zuma Incorporated. It's now Zuma Ndlovu Incorporated. But it's the same company, basically. It's just went in and filled in a name change form with the CIPC. That is an assignment that is in line with the Section 217 prescript. So it's an assignment that you can consent to, and you won't be found foul of Section 217. I think it's also the same with your example, where when you
Sure.
look at the fact that it's basically the same people that are
Correct.
doing it. Correct. It's just that because there has been an acquisition by a certain company, some of the contracts that I have seen that we sign with I must just say upfront that I work for IDFC, which is a Schedule 3D entity, which could be a bit different from government departments. But we do have clauses of where we will say, if there is going to be a change of control of the service provider, we must be notified and our consent must be sought.
Correct.
Before we acquire and we give our consent there. So for me, I think they were just being cautious and by issuing this treasury note, but in terms of your discussion points here.
Thank you.
I think, yes, a new tender process can be entered into, but if the conditions for cancellation of a contract exist, and that would be that, firstly, you deny granting them your consent, then they go ahead and then they default, then you cancel, then you issue a new tender process.
CK?
Yes, thank you.
Thank you for that. What you've just described, though, is what the General Conditions Contract 19.1 says. Right? This is not allowed, but if you write to us, then we'll look at that and we'll consider it. And you've given some examples where it might be right to do that. My reading, and maybe I'm over-reading the instruction, which does apply to 3B and 3Bs and Schedule 2s, is that they're going to change this. They're going to take out this except for the purchaser's prior written consent. They're just going to say it's not going to be allowed. And so I'm just asking and saying, well, we've got a project team in place. We've got a name change that's taken place, and you can't assign it. That's what they're saying in the instruction, is they're not going to. And if you continue, and if you do then agree to the assignment because it makes sense, that will be deemed to be irregular. And so they're taking that away now. This is going to change, and they're going to take this, except with the prior written consent of the, they're going to take it out of the GCC.
Oh,
now,
no, I understand. I understand you.
Now, that's my concern, is that we then cancel a contract, we're 50% through. I mean, you can imagine the issues of a construction contract where you've got people on site, you've got material that's been secured, and an assignment happens, I understand, in the construction industry quite often. But agree with you, and so I'm just posing this question. I have written to Treasury to ask them to really unpack, is that what they mean? Is that even if there is good grounds for assignment, as you've described, the implication is cancel and start a tender process again. Thanks, CK. Any other comments? Hello, Sanele. Please tell me I'm over-reading the circular.
Sean, firstly, before I even comment, I just want to, I haven't had time. One has been quite occupied lately. I think also even Mr. Mokwa can testify to that. TK. I just want to understand, besides the fear of misalignment to Section 217, what is the abuse that probably the National Treasury is trying to prevent by issuing this instruction? I haven't had enough time with this instruction and circular. So if you can probably assist me on that, Sean, what is the abuse that the National Treasury is trying to prevent? Is it that maybe the suppliers or service providers are being awarded, then transfer the contracts to others immediately? Or what seems to be the underlying case beside 217?
It seems that that's what's happening. And I'm in touch with another advocate down in one of the municipalities in the Western Cape, and he's done some research on this. And apparently it's quite a frequent occurrence where organs of state are awarding it to supplier A, and soon after that award, they then give it to somebody else. There's a payment that gets made to the winning bidder, and there's some referral fee of some sort like that, and then somebody else is given the job to get the job done. So apparently it's happening quite frequently, and so it seems to be abuse of the system. There's somebody who's very good, they've got all the stuff that they need in order to win a contract, but they don't feel like doing it. They win the contract and then they assign it to someone who gets to finish it off for them, and they get a bit of a payback referral fee for that effort. But they thereafter have no obligation on that contract. The assignment happens. So apparently it's happening fairly often, which is what Raymond said. This is trying to, so it's not just a principle thing. It is happening practically.
Okay. No, let me note that down. I'll come back with another comment.
All right. So yeah, let's see. Thank you. It looks like there's point from Henry. One principle of cost fairness should not be read in isolation. Another principle says cost effective. That's a good point, Henry. We cancel the contract, I would argue that it's not cost effective. That is one of the issues, but it's also, there's real implications. We're busy with the road. We're 50% along the way. We've got teams on site. We've got people on site, and the kind of plain reading of the circular says cancel the contract and go out and tender again. Now, it could mean, and this has not yet come out for local government, for MFMA institutions, it could mean that this is one of the circumstances that we build into the PFMA policies, CK. The instruction 3 that came out this year said that that for different circumstances, if you describe those circumstances, that could be a means then for deviating from a competitive process. And it might be that to comply with the instruction, and I'm going to just focus specifically on the instruction, to comply with this instruction, we cancel the contract, but we deviate on a single source directly to the new entity that has acquired, or the new entity, or the entity with a different name, and we go directly to that. So it might be that we have to do that, but that would require that we put that condition into the policy. That instruction 3 for the local government folk has not yet been issued, but it talks all around those deviations. Okay, let's move on then to, unless there's another hand. Hey, Tsike.
Thanks, Sean. It is. I think you've just, because as I was sitting here, I was just thinking, I think the instruction note was just an overreaction to try and, it's like taking out an AK-47 to try and shoot down a mosquito that's giving you trouble.
Absolutely.
But with you now talking about the extraction 3, I think you are on the right track. But my problem with that would be, I would then have to think upfront of all the possible scenarios that may happen that could be acceptable for me to assign, right up front, without giving me a chance to treat each case on its own merit. Because then in my policy, I must put down circumstances where that kind of deviation would be acceptable.
Or it's just, in the event or the circumstance of a session or assignment, you just keep it at that level. But it is raising an issue, and we've had discussions on that instruction 3 before. It's the implication of that instruction, I don't think has been really worked through very well. But yeah, absolutely, TK. The other thing, TK, just to put to you is my question that I'm asking at the back end here, to say, does it mean that you should, in order to be compliant, so like I see your hand, in order to be compliant, you actually have to put a special condition in straight away? because the GCC is not changed. So because the instruction has come out, do you have to put a special condition of contract in your tender documents as of the 1st of September? Swanaka, welcome. Yeah, I can see you've unmuted. We can't hear you yet. We can't hear you yet, Swanaka. I hope you can maybe just either have somebody else who's got a working microphone come in, or maybe put your comment into the chat. And Lindiwe says National Treasury always addresses public challenges through issuing an instruction without really getting to the crux of the problems. I do understand challenges with assignments, however, each case must be dealt with, and based on its own merit, it is easy and convenient for them to just put that in to say thank you, Lindiwe, and yeah, Zwanaka. So I hope you can try and find some other way to get your question through. I'm going to move forward and just talk through then. Hi, Karabo.
Yes, Sean. So
Yes, hi.
when you said research has already or is being done, you mentioned a colleague who's in the legal profession. How far has it gone? Like, has it been tested in court?
Many.
Or is a situation? I mean, I think you gave examples about you know, that it has actually happened, but has this gone as far as being tested? Or by the way, this is a new circular, right?
So it's a new circular, but there are a number of court cases where this has been contested, and we're gonna get, hopefully we're gonna get the recording from the PINK program quite soon.
Yeah,
and we'll be able to go that. But I did do some research last week into this, and I did find a number of court cases where this has been discussed, and it's mainly been, you know, where they've clearly abused the process and it's then being challenged.
Yeah, because I think my concern also is on what impact does this have on service delivery and also
Cost.
legally. Yeah, because I mean, I know the courts have also seem to be moving away from just like a robotic approach towards to these matters. They are more and more putting the responsibility on administrators to really apply our minds to different scenarios as and when they come up, and make like informed, like judgment calls that are really informed by substance, rather than a circular says I must cancel, therefore, you know, I'm not sure if that will satisfy you know, the what do you call this? If you are looking at the prospects of succeeding in any court, I don't think you can just merely rely on simply canceling because circular says. So I don't know, there are just so many factors to be taken into account here, and yeah, the legal costs also, should it get to that, where I'm saying, I mean, how do I force you to or you know, demand specific performance under circumstances where you say I cannot perform, and you know, due to reasons beyond my control. So yeah, there's a lot. I also feel it may be an overreaction as well, because I feel institutions or entities should be given an option to evaluate, you know,
Circumstances.
Circumstances.
Yeah. Very, very good. Thank you. Looks like, thank you, Kalaba. Looks like Zwanaka's audio problem's been sorted.
Hello, Sean. Am I audible now?
Yes, you are. Welcome. We can hear you.
Okay, thanks a lot.
Welcome.
Sean. I work for a private company.
Okay.
which had a contract to carry out some engineering work with a state-owned entity. And some 2-3 years ago, the company undertook a carve-out process, which resulted in 2 companies.
Right.
So company 1 retained the original name of the company that was successful in the bidding process and had been awarded this contract. And then company 2 was now a totally new legal entity. So the carve-out was done along business units.
Gotcha.
So the business units where this project was located now fell under company 2.
With a new name, new company.
With a new name, with a new legal entity, yes,
Yeah.
which necessitated assignment from company 2 to company 1. So I just wanted to get your yes, yeah, company 1 to 2 years. Sorry for that.
Yeah.
I just wanted to get your view in the context of this instruction. Would assignment be impermissible?
As far as the strict interpretation of this instruction is concerned, no. It would then mean that that would need to be cancelled and a new tendering process would have to be started. That's my reading of the instruction in the circular. Because I don't understand, your point that you've raised now is this one here. You probably did in that instance approach the organ of state and request this assignment and explain the rationale and the background to it, and that the same people who started the project, the engineering project, are going to continue and recommit to the deadlines and things like that. And therefore the organ of state would, under this condition of contract, would have then thought that that was a reasonable request and then granted the request. This is,
yes,
it seems like this is going to be taken away from the organ of state and they will not have that option. Go ahead, Swalaka.
Yes, we did approach, if I'm to be factual, we did approach the organ of state. We requested an assignment, but this was 2 years before this instruction, and the assignment was granted. Yes.
Yes, and that
FED conditions of contract. Yeah.
Was it under FED conditions? Okay. Yeah.
Yes.
Yeah, and all of those contract forms, FEDEC and JBCC, have assignment conditions in them. But this instruction seems to override all of that, and is not taking any of that into consideration. So, thanks, Swalaka. That's an interesting, another practical, interesting example.
Okay, now thanks a lot for your
appreciate your input. Thank you. Let's briefly just look at the session and just understand what the session is all about. Before we go there, Leb was just saying undue cancellation of contracts will have a detrimental effect on service delivery. Cession of contracts refers to the transfer of only the rights of a service provider has in terms of the contract, of only the rights of a service provider has in terms of the contract from a third party. In commercial contracts, the main right involved is the right to be paid for services rendered, while the appointed bidder remains the service provider that will continue to render the service. The service provider may cede its right to be paid for the services to a third party. So company A is going to continue doing the work, but they're saying, please give the money, the payment for the services, to a third party. This means that the service provider renders the service to an organ of state, while the organ of state pays for the services rendered to a third party, instead, most commonly, a financial institution. What 4.2 is saying, that this is permissible within the SM legal prescripts. However, it's important that the application of Cession be carefully regulated to limit possible abuse instances. And therefore, it is for this reason that the application of Cession be limited only to those Cession agreements in favor of a registered financial service provider and the state institutions established for the express purpose of providing funding to businesses and entities. So they're saying that that session idea can happen, but the payment can only go to a financial service provider or one of the organs of state that is providing funding to business and to entities in that respect. And then they go through, and this is exactly the same in both the circular and the instruction. Sessions must only be applicable to the transfer of rights for payment, right to payment for services rendered by a service provider to an FSP or state institution. The written request for session must be by the service provider and not the third party. And then finally, the written request by the service provider must be accompanied by the session agreement. And that will be allowed. And just asking some questions here on some practical instances where it might be in the favor of another entity. And I'm trying to tease some of the things out here. Sometimes it happens that there's a consortium or an unincorporated JV. And we've got, or a prime contractor and subcontractor. So they submitted, but now the prime contractor is saying, hang on a sec, we can't do this work. We've been liquidated or for some other reason, but the subcontractor, the other entity, is going to continue to do the work. Please don't pay us, pay them. And this is then saying that won't be allowed, but what will be allowed is where they said, don't pay us, pay them, pay their bank. And that's what this is saying. What are the implications of this, and how can this be made to work in order to comply? And then I'm also asking, should special conditions of contract be included then in your tender conditions to make this work and to make that clear? One of the examples that we had last year when the draft came out was we had one of the organs of state that was online with us. She shared this with me afterwards. She didn't share it with us online. She said that she's got a legal entity, a legal firm, and that particular legal firm delivered the work, but there were delays in payment. Lots of issues around delays in payment. And in fact, it was months after the work was actually completed, that particular legal entity, that legal entity that did the work said, no, we've done the work, that entity did the work. All you've got to do now is pay this one. And it was a new legal entity. The advocate that had done the work left that particular organization, has gone to another entity and requested that the payment rather be made to the other entity, to the new entity. So that was just one of the examples where the session would apply. And they're saying, yeah, that it can only happen in instances where the payment is made to a financial services party. Any comments? This can probably be made to work without any real significant implications. I think that for me, the key one is we probably need to put some points in our in special conditions of contract just to make sure that this is applicable. Hey, Komoto, welcome.
Thanks. Hi, Sean, and hi, colleagues.
Good morning.
I think my comment would be from the side of the financier. I am currently doing providing purchase order funding in Limpopo, and this is how we work. We work with sessions, so it has been working properly, and I don't really think we need to have provisions in the SCCs to make it, because otherwise you'd have SCCs that would cater for each and every possibility in law. Where and I think maybe I appreciated the circular in that, or the instruction note in that it puts a split between where previously people would cede the work, therefore going against the provision of section 217, where, yeah, so because the practice here in Limpopo, I don't know, in other provinces, has been that people would get contracts, say for instance, the school feeding program, and they are big, maybe 3 big players in the province, and every single one of those that had gotten that contract goes to those one of the 3 big companies and sees the contract. So the big companies will deliver the services, will invoice and all that, therefore going against Section 2 and 7.
Right.
But now the split between the Cession and the assignment is that now you're saying, here it's a service provider, got a contract, they don't have funding to deliver on that contract. We provide funding to them, and as part of our security, we then sign a session where then they only see their right to a payment to ourselves. You have some institutions that would say, okay, fine, we would split the payment. So if they need to pay 100,000 and 50,000 to me and 50,000 to the contractor, they will do that. But some institutions would just, basically what they will do is replace the order.
Got you.
Yeah, so after the award, they issue an order in the name of that particular awarded bidder. And after we sign the session, they replace that order with our name, so that then they pay us, we pay the contractor, because the contractor would have ceded only their right to a payment to ourselves. And it's been working, because I mean, you in the space you're dealing with service providers that ordinarily may not be able to access funding in the, in the normal banking sector. But I think the one issue that I found problematic with the instruction, I've written to Treasury, and unfortunately I'm not winning with the response. It's their inclusion of the word FSP, financial service provider. They need that it's no longer a requirement for you to be an FSP. If you're providing only credit, you register as an FSP if you're also providing financial advice or selling, your other products such as your life covers or insurance to cover your credit. So I don't do that. So, and same as other state institutions that provide funding. In Limpopo, for instance, we've got the Limpopo Economic Development Agency, which provides that purchase order funding. They are not an FSP, but they are an NCR accredited registered service provider. So we are required by law to register with the National Credit Regulator and not necessarily the FSP, because we don't sell other services. So I think that is the only hiccup that I have with that instruction note I've written to Treasury. And I think in August already, and I'm just not getting joy there. Thank you.
Well done, Komotso. So you're not an FSP, but you are registered with the credit regulatory body to provide credit. And so maybe the amendment would be to include that as well as FSPs. So
yeah, because Limpopo had issued one, and they've made it clear. So it's proper. It does talk to NCR, but the national one fell short of NCR. Yeah,
well done on the work that you're doing there. Thank you.
Thank you so much.
All right, if there are no other comments, let me quickly jump to another